Ready, start. Respondents 1 and 2 are compositors of the printing press belonging to the petitioner. In October 1975, they are filed a joint petition before the Labor Court under Section 33C(2) of the Industrial Dispute Act, claiming difference between wages actually paid and wages payable under the Minimum Wages Act. The first respondent's claim was for the period from 1/8/1967 to 30/9/1975, and the second respondent's for the period from 1/2/1969 to 3/9/1975. Overruling the objections of the petitioner's employer, the Labor Court held that the respondents were entitled to get rupees 3,400 and rupees 1,500 respectively. This writ petition is directed against Exhibit P6 order of the Labor Court, para. It was contended before the Labor Court that the petitioner was bound to pay wages only at the rates specified in Exhibit P5 Agreement of 1974. The contention was rightly rejected by the court in the light of Section 25 of the Minimum Wages Act, which declares as void all contracts or agreements providing for payment of wages at rates lower than those fixed under the Act. The petitioner may be right in his contention that the belated claims for arrears for more than 8 years in one case and 6 years in the other were filed as a measure of retaliation against disciplinary action, and that but for such action the employees were willing to receive the rates of remuneration fixed in Exhibit P5, but that cannot affect the operation of Section 25 of the Act, nor was the Labor Court competent to reject the claims on the basis of Exhibit P5. The more important point raised before the Labor Court was that claims enforceable under the Minimum Wages Act could not be agitated in proceedings under Section 33C(2) of the Industrial Disputes Act. The Labor Court observed that even barred claims under the Minimum Wages Act could be advanced in a petition filed under Section 33C(2) of the Industrial Disputes Act. Counsel for the petitioner is apparently justified in contending that the scope of the objection has not been fully examined by the Labor Court. The objection urged in Exhibit P2 was in the following terms: the opposite party submits that the petition is not maintainable under Section 33C(2) of the Industrial Dispute Act. The claims made in the petition are for a computation of wages under the Minimum Wages Act, which is not entertainable under the provisions of the Industrial Disputes Act. The Minimum Wages Act provides the machinery for realizing the amounts due to the workmen who are paid less than the minimum. Section 20 of the Minimum Wages Act specifically provides the machinery, and the authority is also appointed who alone has got the exclusive authority and power to grant the prayers claimed in the petition. The petition is hence not maintainable. Para. Clearly, the objection was not to entertainment of barred claims only, but to claims of any kind on the footing that Section 20 of the Minimum Wages Act provided for a machinery for enforcing claims under it, and that consequently such claims were outside the scope of Section 33C(2) of the Industrial Disputes Act. In other words, claims enforceable under Section 20 of the Minimum Wages Act could be enforced only by the authority appointed under the provision, and not by an authority appointed for different purposes under a different enactment. Drawing inspiration from the decision of the Supreme Court in State of Punjab versus Labor Court 1981, Counsel now puts his point on a clearer basis by contending that the Minimum Wages Act is a self contained code incorporating all provisions relating to payment of minimum wages and that its provision impliedly exclude recourse to any other forum. Para. The appropriate government may, by notification in the official gazette, appoint any commissioner for worksman compensation or any officer of the central government exercising functions as a labor commissioner for any region or any officer of the state government not below the rank of labor commissioner or any other officer with experience as a judge of civil court or as a stipendiary magistrate to be the authority to hear and decide for any specified area all claims arising out or payment of less than the minimum rates of wages or in respect of the payment of remuneration for days of rest or for work done on such days under clause B or C of section 1 of section 13 or of wages at the overtime rate under section 14 to employees in that area. Where an employee has any claim of the nature referred to in sections, the employee himself or any legal practitioner or any official of a registered trade union authorized in writing to act on his behalf or any inspector or any person acting with the permission of the authority appointed under section may apply to such authority for direction under section 3, provided that every such application shall be presented within 6 months from the date of which the minimum wages or other amount became payable. Provided further that any application may be admitted after the said period of 6 months when the applicant satisfied the authority that he had sufficient cause for not making the application within such period. When any application under section is entertained, the authority shall hear the applicant and the employer or given them an opportunity of being heard, and after such further inquiry, if any, as it is may consider necessary, may without prejudice to any other penalty to which the employer may be liable under this act, direct in the case of a claim arising out of payment of less than the minimum rates of wages, the payment to the employee of the amount by which the minimum wages payable to him exceed the amount actually paid, together with the payment of such compensation as the authority may think fit, not exceeding 10 times the amount of such excess. In any other case, the payment of the amount due to the employee, together with the payment of such compensation as the authority may think fit, not exceeding the 10 times, and the authority may direct payment of such compensation in cases where excess or the other amount due is paid by the employer to the employee before the disposal of the application. Para. If the authority hearing any application under this section is satisfied that it was either malicious or vexatious, it may be directed that a penalty not exceeding 50 rupees be paid to the employer by the person presenting the application. Any amount directed to be paid under this section may be recovered. If the authority is a magistrate, by the authority as if it were a fine imposed by the authority as a magistrate, or if the authority is not a magistrate, by any magistrate to whom the authority makes application in this behalf as it if were a fine imposed by such magistrate. Stop.